Yeah, no, I was just going to give you one and hold on to it.
All right, Mr. Kuhn.
Yes, sir.
The court has conducted the in-camera view. The court finds that the information from the Department of Social Services is relevant material and cannot be accessed except through these documents. So I'm gonna turn those over to the parties for viewing, and if you will give me an order whenever you get an opportunity to that effect, and limiting the distribution of that. So,
Just give me a copy. Should I work with Ms. Ellis to make
Right.
them copy?
We can make a
Sure.
copy.
I appreciate it.
Thank you.
all right, are we ready to proceed?
Yep.
You want to wait for the train to go by?
I think so. I think that is what I was doing. So I was about to show the witness what's been marked as defendants 15. No objection, Your Honor.
All right.
Ms. Clement, do you recognize this document? Or these materials, I should say?
Yes, I do.
And was it the regular practice of LabCorp to prepare these materials as part of the DNA testing conducted in this case?
Yes, it is.
And what is contained in this packet of materials?
This is the case file, which includes all the documentation of what was submitted. It includes the raw data of the testing results, as well as copies of the report and communications with various individuals during the process of testing the samples that were submitted.
And did you review these materials to reach the conclusions that you testified to today?
Yes.
And did you in fact interpret these materials and draw conclusions based on them?
Yes, I did.
And does this case file and the underlying data in this packet of materials support the conclusions that you testified to today?
Yes, it does.
Now, you testified, Ms. Clement, that the report that was marked for identification as Defendants 5, that you prepared this report.
That's correct.
And does this report accurately and correctly reflect the results obtained in performing DNA testing of the items we discussed today? Item 59, the vaginal smears of Nishonda, Washington. Item 60, the rectal smears of Nishonda, Washington. And item 62, the vaginal swabs of Doris Washington.
Yes, it does.
And does this report accurately and correctly reflect the results obtained from comparing the DNA profiles from those items to the DNA profile of Darryl Howard?
Yes, it does.
Was Mr. Howard conclusively excluded as the source of DNA in all the samples tested by LabCorp?
Yes, he was.
Based on your expert opinion to a reasonable degree of scientific certainty, can you say whether Darryl Howard was the source of any DNA on any items tested from Doris Washington's sexual assault kit?
He was not.
Based on your expert opinion to a reasonable degree of scientific certainty, can you say whether Darryl Howard was the source of any DNA on any items tested from Nishonda Washington's sexual assault kit?
He was not.
Based on the data and the DNA results that LabCorp obtained, is there any scientific evidence to support the conclusion that Darryl Howard had any sexual contact with Nishonda Washington or Doris Washington?
No, there is not.
And based on the data and the DNA results obtained, There is, however, scientific evidence that shows that Doris Washington has had sexual contact with Jermac Jones, correct?
Yes.
And based on the data and the DNA results obtained at LabCorp, there is scientific evidence to show that 13-year-old Nishonda Washington had in her anus sperm from a second man who, as far as you know, is unidentified, but who we know is definitely not Jermac Jones. Is that correct?
That is correct.
Your Honor, I would move to admit, I'm doing this a little out of order, Defendant's Exhibit 5, which is LabCorp's 2010 report, and then Defendants 13, 14, and 15, which are the case file, the photocopies, and the SBI report of the match between Jermac Jones and Doris Washington's vaginal swabs. I'm sorry, that was 12. And the statistics sheet of Nishonda Washington's rectal and vaginal smears.
All right, your motion is allowed.
So I think everything has been admitted except we haven't asked for 10 to be admitted. That was just a demonstrative, that diagram. That's my understanding. I've no further questions of this witness.
All right, cross-examine.
Thank you, Your Honor. Megan, good afternoon.
Good afternoon.
You stated that you've gone through Defendant's Exhibit number 15, and that's what you drew a lot of your conclusions from?
Yes.
Okay. Did you review the trial transcript at all?
No, I did not.
Did you review any of the police reports?
No, I did not.
Did you review any of the autopsy reports?
I did review some of the autopsy reports, yes.
Some of the autopsy reports?
I'm not sure whether I was provided some of the autopsy report. I don't know whether it was the entire autopsy report, but I have seen autopsy reports, or at least a portion thereof.
Portions? And who provided these portions?
The New York Innocence Project.
Okay, so all of the items that you were able to look at all came from the Innocence Project?
Yes.
Now, you weren't dealing with any of the attorneys at the table, correct?
I'm not sure I understand your question, dealing with them when I was performing this testing.
Correct. When you were performing this testing, with whom were you dealing?
I was dealing with Mr. Jason Craig.
In fact, you kind of went back and forth a lot with Mr. Craig.
Yes, that's correct.
And then after that, how long before anybody contacted you about this again?
It was while I was in Texas, I believe, so I'm not sure of the exact date. It was probably sometime around the date that the statistics letter was dated.
Okay, so that was in 2013?
I believe so, yes.
So that means that the DNA information for the CODIS upload came back to you in 2010?
Well, the information didn't come back to me. The North Carolina State Crime Lab does not notify LabCorp when a hit is made. That notification was made, I believe, to the police department and then to the to the New York Innocence Project. I was made aware of it sometime between the time that we provided the documentation to the state lab and sometime before 2013. I was made aware that there had been a hit, but I don't know the exact date, and I wasn't provided any documentation of the hit. I was just verbally notified.
Verbally notified. And are you familiar with the standard operating procedures for labs once they get a CODIS notice?
Yes.
And what is that procedure?
Generally, once they get a notice that a hit has occurred, a second reference sample or a new reference sample is collected from the individual for confirmation that the hit is accurate.
So in this case, the hit actually came back to Jermac Jones.
Yes, that's correct.
And the policy would be then to collect a second standard from him in order to make sure that that CODIS hit is a match, correct?
To collect a sample, yes, rerun his reference sample to compare to the evidence, and then report on the comparison to verify the match.
And in this case, you reviewed that and it actually occurred. The police department went out, got a second sample, and were able to send that to the lab for that CODIS hit evaluation, correct?
Yes, they sent it to the North Carolina State Crime Lab.
Now, during your review of the case file, were you given the communications logs with the lab? You reviewed a lot of the other portions of that.
I had some communications. I don't know whether I had all of the communications. I did have the communication between the Tennessee State Lab and the North Carolina State Lab, notifying them that it hit. And I did have, I believe, some communications between the North Carolina State Crime Lab CODIS administrator and emails requesting a new sample from Mr. Jones.
Did you have the full SBI file?
I had portions of it. I'm not sure I had the whole file.
Okay. And during any of this, were you ever made aware of what the victims were known to have done during their lives?
I certainly was, yes.
And were you aware that Doris was actually a user of drugs?
That was my understanding, yes.
And did you also know that there were allegations in this case that she actually sold herself and others for drugs?
Overruled.
I believe that that was indicated as a possible.
Thank you. Did you also know that the daughter, Nishonda, had been missing for several days prior to this?
Objection, Your Honor. There's no evidence of that in the trial transcript,
Sustained.
unless you would like to show it to me.
You have another question?
Sure. Oh, I thought you said you had a approach. So you didn't look at the total
No,
reports?
he said there was no evidence at the trial unless you want to show him.
Oh, Your Honor, I do have evidence. That was the case file, the DSS reports that were actually looked at in, that we just received. That was done with an in-camera review with the judge and the attorneys, and that was also in the regular file that...
Not introducing the evidence.
Your Honor, this is totally different from what his argument is, where Peterson is concerned. I understand what his argument is, stating that we can't introduce evidence that shows beyond the scope of the MAR hearing, but this is showing linkage in that case. This case right here is totally different from Peterson in that this evidence that we're eliciting is just showing that there's no linkage, not that there is, that we're attempting to introduce collateral evidence that would show that the a jury would have came back with the same verdict. This is totally different. What we're showing here is that there is an absence of a linkage for them to argue some of the facts that they're attempting to argue. They have the burden to prove that there is linkage. We can show that there is no linkage.
All right.
But Your Honor, and just so I can address that, the testimony, we're talking about Nishonda, so we're talking about the intact sperm that were found in her. The testimony is that those deposited less than 24 hours before they were collected. According to the autopsy report, they were collected on the morning of the 28th. These women were murdered at around 1 a.m., I guess, or the morning of the 20th, about 1 a.m. on the 27th. So whoever had sex with her had to do it within that 24-hour window before the collection. And where she was 4 or 5 days previously doesn't doesn't have anything to do with it.
Yes.
Your Honor, there was evidence in there that they stated that the officer, and there's notes in the whole case file that they have, that the investigator actually stated that Nishonda returned the day that she was murdered.
Right. And what I'm pointing out that the state hasn't latched onto yet is if somebody had sex with her before the day she was murdered, their sperm would not be intact in the sample according to this witness. Somebody had to have sex with her within that in less than 24 hours before it was collected the following morning, which means she had to have sex with somebody that day or just before she was murdered, not the night before she's murdered and not 3 days before she's murdered.
Yes, Ms. Ellis.
Thank you, Your Honor. That is exactly my point, is that there's a 24-hour window.
But he's saying you're in excess.
Your Honor?
You're in excess of that window is what he's saying.
I am not the person who has the burden to show that window. And I can talk with the expert who can. And, Your Honor, what I'm stating is that there is a 24-hour window and that he can't prove that somebody else didn't sleep with them in that 24-hour window.
In fact, I agree with you. I'm just saying it's
Say it again.
I said I agree that somebody else had sex with her in that 24-hour window. It's the killer.
All right. His objection is sustained.
Thank you, Your Honor. So you have a lot of background with DNA.
Yes, I do.
And looking at this case, there was a showing of sexual contact with Nishonda, correct?
Yes.
And were you able to look at the trial transcript? You weren't able to look at the trial transcript at all.
I did not look at the trial transcript.
So if I were to tell you that there was no signs of sexual assault in the trial transcript, would that change your view in any way?
Objection, characterization.
What is it? You don't understand?
No, I understand the question, but to say there are no signs of sexual assault, we have two women who were found naked. There's semen in one of them, they've been strangled, and there's a laceration up in the other one's vaginal canal. I think it's an unfair characterization to say there are no signs of sexual assault.
Yeah. Is that what you mean, Ms. Ellis?
Your Honor, what I'm going to say is that there is no doubt in anybody's mind that these two females were killed. They were brutally murdered. There is no doubt that they were found naked. However, you can have a sexual assault without a murder, and you can have a murder without a sexual assault. And, Your Honor, that is what we're attempting to elicit by questioning all of the evidence together, not just one or two or three pieces, but looking at the totality of the circumstances and establishing what that evidence states. And according to the trial transcript, there was redness, but there was no tearing or any other notion in the trial
Understood.
transcript.
I understand it. Go ahead. Overrule. Ask your question.
Thank you, Your Honor. Now have you
Did you ask the question?
Excuse me?
Did you ask the question you wanted to ask?
No. Would that change your
My
Opinion.
opinion as to whether a sexual assault,
yes? If you knew that there was just redness around the vaginal area and no other markings?
no, that would not change my opinion at all. In probably the majority of sexual assault cases, there is no evidence, physical evidence of the actual sexual assault. So it's not uncommon to not have tears or to not see physical evidence when a sexual assault has actually occurred.
Well, let's talk about sexual assaults versus consensual sex. What are the differences there that you see?
This is actually outside of my scope. I have never actually examined a sexual assault victim, and I've never actually been involved in collecting a sexual assault kit.
So therefore, stating that this was actually a sexual assault is not in your purview and not something that you can state here on the stand in this case.
For Doris Washington, where there's a laceration in the vaginal vault, that is clearly indication that some sexual assault had occurred.
And the sexual assault in that case, though, you weren't able to read the transcripts or anything like that?
I was not.
And you didn't look at the autopsy reports?
I did look at the autopsy report.
And so the autopsy report actually in there stated that it was a sharp object that was shoved up in the vagina. Is that correct?
Yes, but that's a type of sexual assault.
Yes, that is a type of sexual assault. However, it's not a penis.
No.
And would a knife or a sharp object leave spermatozoa in a vaginal cavity?
Not unless it was contaminated prior to being inserted.
Thank you. Now, looking at the motion, were you able to look at the defense motion for the DNA testing?
Yes, it was provided before I picked up the samples.
Okay.
Maybe, I'm sorry, let me correct that. I'm not sure I saw the motion. I did see the court order.
You saw the court order?
Yes.
But you didn't see the motion then?
I don't recall if I saw the motion or not.
Okay. And actually looking at your things here, can you tell me what redundant matching profile would be? What's a redundant matching profile?
To me, a redundant matching profile would be the same profile from different items of evidence.
Okay. Now, if I told you that their motion for testing in this case was based on looking for redundancy in the profiles, what would that make you think of?
That they were looking to determine whether the same donor had deposited semen in multiple areas
And this would this pertain only to semen?
or other DNA.
And what other types of DNA? Where would you look for other types of DNA?
Oh, there could be any number of different types of DNA. You can find DNA from touching something. You can find DNA from spitting on something. I mean, so DNA can be deposited in any number of ways.
Okay. And going back, do you have all the exhibits up there?
I do not. I only have Exhibit 15.
Okay. I'm going to show you what's been marked as State's Exhibit number 8. Permission to approach, Your Honor?
Yes.
You mean defendant's exhibit number?
Defendants, thanks. I'm so used to being a state. Thank you. I'm going to show you what's been marked as defendant's exhibit number 8. Can you identify that?
Yes, Defendant's Exhibit 8 is the chain of custody documentation from LabCorp.
And that's already been introduced as evidence.
Yes,
And that's your report.
yes.
And on that, how many pieces of evidence were sent to your office for testing?
11.
11 items. And What were those items?
There was a vaginal smear from Nishonda, Washington, a rectal smear from Nishonda, Washington, oral swabs from Nishonda, Washington, vaginal swabs from Doris Washington, rectal swabs from Doris Washington, oral swabs from Doris Washington, right-hand fingernails from Doris Washington, left-hand fingernails from Doris Washington, a blood stain on cloth from Nishonda, Washington, blood stain on cloth from Doris Washington, and an oral swab from Darryl Howard.
And on how many of those items did you find DNA?
We found DNA, well, on virtually all of the items, we found DNA.
Did you find any redundant DNA?
We did. We found redundant DNA on the vaginal smear from Nishonda, Washington, and the rectal smear from Nishonda, Washington.
And were you ultimately able to find out who those two contributors were?
That was one contributor that was consistent with originating from the same source, and no, we never had a sample that was consistent with the evidence.
Okay, and that was only in the vaginal and rectal of...
Nishonda, Washington.
Okay. Did you test the fingernails scrapings?
Yes. The fingernail scrapings from the right hand matched the profile of Doris Washington. We did not find anything foreign.
Now, going back to the vaginal and rectal that were partial in Nishonda, can you describe what type of DNA you found?
We found the male DNA in the sperm fraction. So it's consistent with originating from sperm.
Were you able to find any sperm heads?
I'm trying to find the actual communication. I did microscopically look at the smears, and I did observe sperm heads. I would never identify a tail by itself. I just can't remember when exactly that is, and I'm not locating it directly in the correspondence, but I did microscopically identify spermatozoa.
And from that spermatozoa, were you able to determine how long that had been deposited?
No.
So from those two redundant DNA, you were not able to conclusively say when that DNA was deposited in Nishonda?
Not from my personal observation, because I know I saw heads. I don't remember seeing tails. I remember seeing heads.
And how long can sperm heads remain in a vaginal cavity?
Sperm heads can remain in a vaginal cavity for, there's been some literature, upwards of 5 days or more.
5 days or more.
Yes.
Now, did you know anything about the scene or how these women were found?
I don't remember at what point I found out how they were found at the scene. Let me look at some of the communications and see if I... I believe I had some preliminary information.
So you knew that they were not in the spot where they found them originally, when they were actually taken out by firefighters?
I was not aware that they were taken out by firefighters. I do know that the bodies were taken to, I'm not sure I understand. I know that the bodies were taken to the medical examiner's office, and that's where the evidence was collected.
Okay, they were collected there.
Yes.
But did you know anything that happened before the bodies were taken to the medical examiner's office?
I don't believe I had any of the details.
So you had no details that they were found in a fire, that they were taken out by firefighters, that there was a crowd of people around them? Any of that history was not given to you?
I don't remember that it was, no.
Okay. In your expert opinion, based on your training experience, can you have a murder without a sexual assault?
Yes,
And can you have a sexual assault without a murder?
yes,
And can you have consensual sex without a murder?
yes.
And based on all of this evidence, can you conclusively say that Darryl Howard did not murder these two women?
There's nothing to indicate that there was any contact from any of the evidence that I tested between Darryl Howard and these women.
Is there any evidence that proves that he did not kill these women?
Objection.
What's your objection, counsel?
The objection is it's my obligation to prove by preponderance of the evidence that this new evidence would raise a reasonable doubt in the mind of a reasonable jury. She's now saying I have to prove a negative, which is he didn't do so.
Sustain.
Were you aware that this has already been litigated before, that the Court of Appeals had looked at this case and ruled that there was enough evidence against the defendant without any DNA to convict him of these crimes?
I was not aware that the Court of Appeals had looked at it. I was aware that it had gone to trial and there was a conviction.
Were you aware that they previously had put before the jury that he did not match any of the samples that were provided to the SBI, and that that was put before the jury?
I knew that there was DNA evidence presented at trial, and that Mr. Howard was excluded from that DNA evidence.
Thank you. Thank you. No further questions, Your Honor.
Redirect.
Can we have a few minutes?
Yes.
Just ask her, could you?
Ms. Clement, Ms. Ellis asked you a couple questions about Doris Washington and a sharp object being inserted into her vagina. Can a woman be sexually assaulted with a penis and then afterward a foreign object inserted into her vagina after the sexual assault with the penis?
Certainly.
I'd like to ask you a couple questions about whether sperm was identified in the vaginal smear slides of Nishonda Washington.
Yes.
So I'm just going to show you what's been marked as Defendant's Exhibit 11. Your Honor, may I approach?
Yes.
Defendant's Exhibit 11, if you look at case number 748.
I actually gave you 12 also.
Your Honor, if I may, just for a second.
Do you have a page on yours as well? 771, because the page number that was here was for a different victim that doesn't belong to this case, and so you produced another one that actually does belong to this case, but it's out of order.
Thank you. Do you see that page?
Yes, I do.
And what does it say under Nishonda Washington's vaginal smear slides?
It says that sperm were found and they were intact.
And sperm was found by whom?
By the state crime laboratory analyst.
And this is prior to the 1995 trial in this case?
Yes, this was dated February 26th of 1993 that they looked at the smear and saw intact sperm.
Okay. No further questions?
Your Honor, I have no further questions.
All right. You can come back.
Your Honor, we call Professor Marilyn Miller.
Any questions about the Bible and raise your right hand? Do you solemnly swear that the testimony that you should not give the court and the jury in the case now being heard is the truth, the whole truth, and nothing but the truth, so help you God? You can be seated.
Good morning, Professor Miller.
Good morning. No, it's afternoon.
I'm sorry. Been one of those days already. Could you please state your name for the record?
Sure. Marilyn Miller.
And Professor Miller, what is your occupation?
I'm an associate professor in the Department of Forensic Science at Virginia Commonwealth University in Richmond, Virginia.
And can you explain very briefly what you do as a professor in the Department of Forensic Sciences?
Sure. As a tenured professor, I have expectations of doing research in my area. I have expectations of teaching a certain number of courses. Over the years, the courses that I teach have evolved into a series of crime scene investigation courses, a basic course that we call scientific crime scene investigation, and an advanced class, obviously called advanced crime scene investigation. I've been a forensic scientist for a good number of years, so I also teach the professional practices courses that are part of our curriculum, and this is both at the graduate and the undergraduate level. When I first started at VCU, I also was teaching some of the basic forensic science courses and the forensic chemistry courses.
Professor Miller, I'm going to hand you what I've marked for identification purposes as Defendant's Exhibit 16. Can you identify what Defendant's Exhibit 16 appears to be?
It appears to be my CV.
And would this CV set forth your knowledge and, or at least your training and your experience throughout your career?
Yes, sir, it does.
And would it help illustrate your testimony in terms of your expertise?
Absolutely, it would.
Okay. I'm not going to spend a lot of time because it's a thick CV, but I just want to very briefly have you describe to the court what your education is.
I have a bachelor's degree in chemistry from Florida Southern College. I have a master's degree in forensic chemistry from the University of Pittsburgh. And not all that long ago, I got my doctorate in higher ed leadership. So it's a doctorate in education.
And in terms of your employment experience, that's listed under professional laboratory employment?
Yes, sir.
And without going through each position, you've been a crime scene search specialist?
I wouldn't exactly call it that. I started out working in the Pittsburgh Forensic Laboratory, Allegheny County, and did a fair amount of bench time, and as part of that, I was frequently asked to respond to crime scenes. Then when I moved back home to Florida, I was asked to work in 3 different sheriff's departments, forensic laboratories. And at that time, I also was getting involved in going to crime scenes to make the best evidence come into my lab for testing that could come into it. It's a model that's kind of a dinosaur now because now we usually have crime scene investigators who are separate from forensic laboratory personnel, contrary to what we see on television.
But you've been to crime scenes?
I've been to hundreds of crime scenes.
You've assisted in the processing of crime scenes?
I have investigated them, yes, sir.
Okay. And in addition, your curriculum vitae indicates a number of publications, abstracts, and presentations on the next pages?
Yes, sir. Most of my research area, which stems from, where these publications stem from, have to do with getting science to the crime scene. A good number of textbooks were written primarily for both my use in the classroom and also attempting to get science at the crime scene. The research that I'm conducting in my laboratory or with other collaborators are just intended to do that, to show that it is possible to get science out of a lab setting and get it to the crime scene.
And have you given lectures to professional associations of criminalists and forensic science?
And even attorneys, yes, I do.
And you list current professional memberships at the top of page 2. You indicate you're a member of the Crime Scene Death Investigation Scientific Area Committee, Can you explain what that is?
Sure. It's called OSAC is our abbreviation. It is part of a process that is now in place through the National Institute of Standards and Technology, or NIST, and it stems from a report several years ago now from the National Academy of Sciences that talked about strengthening forensic science in the United States. And part of that indicated that there needed to be a concerted attempt by the different disciplines within forensic science to make it more scientific. If you read the report, they say that the only science in forensic science is DNA analysis, but being there are several dozen disciplines within forensic science, this NAS report, along with NIST and the OSACs, put together some content area experts or discipline experts to form these SACs that have various specialty areas of expertise. And I applied and was assigned to the OSAC, that is medical legal, death investigation, crime scene investigation. I've also, out of that process, been named the chairperson of the crime scene investigation subcommittee. And we are a relatively new subcommittee that we are putting together standards and guidelines and best practices for crime scene investigation.
Okay. In addition, it also indicates you're a fellow in the criminalistics section of the American Academy of Forensic Sciences.
That's correct.
And a member of the Southern Association of Forensic Sciences.
Yes.
And as part of your knowledge, your training, your experience, do you evaluate crime scenes?
Absolutely, both in my past working in the area of investigations with law enforcement, but also now, even as a college professor, I'm frequently asked to consult on cases for both prosecution and defense attorneys.
Your Honor, at this point, I tender Professor Miller as an expert in crime scene analysis.
Any objection?
Your Honor, no objection. I'm familiar with her, and I think I've called her myself.
Yes, you have.
All right, motion is allowed.
Thank you, Your Honor. I appreciate that. Professor Miller, very briefly, when we talk about physical evidence, what are we talking about?
Well, physical evidence is, I've seen some describe it as the debris of criminal activity. I certainly, as a scientist, would never want to call it debris. I think it has very, very probative value for any criminal investigation. And so it can be just about anything that is produced as a result of criminal activity, which we most commonly find at crime scenes.
And why is it important to look for and then evaluate physical evidence?
Well, physical evidence is, just as I say, that which is left over or created or taken away from a crime scene. It's the piece that is objective. It is the item that allows us to identify, to eliminate, to link or associate, to refute or to prove what is otherwise very subjective. It is the piece that, when it is subjected to the scientific testing, is that which is the most reliable and valid.
Well, for example, when you have an eyewitness statement, is physical evidence important in terms of evaluating an eyewitness's statement?
Well, absolutely it is. Physical evidence is not subjected to peer pressure. It's not subjected to mindlessness. In other words, people don't forget about it. It is that which is that true objective piece of evidence. And so when eyewitnesses oftentimes forget, or they change, or they have a stakehold in a statement or what they're witnessing, it's very subjective, whereas the evidence is the objective part. But the value in any criminal investigation is the fact that the physical evidence can oftentimes support or refute what eyewitnesses are saying. It's the benchmark of the reliability of the witness.
And to demonstrate that, I'd like to do something from this case, and I'd like to ask you a hypothetical question, if I can. And that question is this: if the Judge Hudson should find from the evidence by its greater weight.
I'm sorry, I didn't hear the first part.
I'm sorry. If Judge Hudson should find from the evidence and by its greater weight that the trial transcript in this case indicates that Ronika Jackson, Kevin Best, and Dwight Moss testified that Darryl Howard and either another man or a man and a woman were carrying a television or a television and an electronic like VCR that went on top of a television. I'd like you to assume that those facts are found,
Okay.
that that's what they testified to at trial. And with that assumption, I'd like to show you what I marked for identification purposes as Defendant's Exhibit 17 and Defendant's Exhibit 18. I didn't write them on here. You recognize Defendant's Exhibit 17 and 18.
I do. These are photographs that were taken of the crime scene.
And can you tell me if they depict televisions at this crime scene?
Yes, they do. They depict a television on a dresser and a console television, I believe, on the first floor of this particular scene.
Once again, I'm just going to object to the leading.
Overruled.
And specifically with respect to, and I believe it's, on Defendant's Exhibit 18, the television that you're referring to, is there a VCR or piece of electronic equipment that would go on top of the television in the chair directly across from the television?
Yes. That was an observation I made when I reviewed these photographs.
Okay. And in fact, does the size of that object appear to fit the dust pattern on top of the television?
I can't say precisely because there are no scales in the photograph, but it certainly could be, absolutely.
Okay. So would this be one example of witnesses saying one thing or remembering one thing, and then the necessity of going to the crime scene to determine whether in fact those things were true?
But this is exactly the type of physical evidence that a crime scene investigator would assist an investigator with, pointing out the fact that there are still 2 televisions in this crime scene. And there is also a piece of electronic, I think it's a Game Boy, I'm not sure, but it's one of those game consoles.
Professor Miller, at my request, did you review a number of materials related to this matter?
I did.
Did you review crime scene photos?
Yes, I did.
Did you review the diagrams and notes that were taken at the crime scene or from crime scene investigators?
I did, yes.
Did you review the testimony of Eric Campen?
I did.
And can you tell the court who Mr. Campen was?
He was the crime scene investigator for the law enforcement agency.
And did you review the testimony of Robert McLaughlin, a first responder firefighter?
Yes, I did.
And did you review the testimony of Roger Vandergraff, a first responder firefighter?
I did, yes.
And did you review a crime scene diagram? That was,
yes, I did.
And did you review the autopsies for both Doris Washington and Nishonda Washington?
Yes, I did.
And based on your review of these materials, your knowledge, your training, and your experience, have you formed various opinions concerning this crime scene?
I have.
I'd like to discuss those with you. And what I would like to do is start with what I'll remark as Defendant's Exhibit 19, but which corresponds to State's Exhibit 3 at Mr. Howard's trial. Professor Miller, have you seen what's been marked for identification purposes as Defendant's Exhibit 19?
I've seen a much smaller version, but yes, I have.
And can you tell us what that is?
This is actually a crime scene sketch that was prepared by the fire investigator. It represents the second floor of the apartment.
So let's, just to kind of orient things, we have one bedroom here.
Yes.
The upper right-hand portion of this diagram. And the fire that was found began in the closet.
Yes.
And then we have a second bedroom on the other side of this wall where the victims were found.
That is correct.
And at least in this diagram, we've got one victim who's smaller than the other one.
It would appear that way, yes. That's what I presumed when I was looking at it.
So it would appear that that would be Nishonda Washington, this would be Doris Washington. They were found nude on a bed.
Yes, sir.
Okay.
There's also, if I might add, a bathroom up the corner and numerous closets as well.
And there was also a first floor to this residence.
There was.
For example, the photograph that you talked about with the dust bag, do you know where that was located or where it appeared to be located?
It's my presumption, and after my examination of the materials, it's the first floor.
Now, the damage that has been discussed, Ms. Ellis mentioned it in her opening statement, there was fire damage in this apartment, was there not?
There was fire damage in that second floor area.
Okay. Was the fire damage confined to the second floor area, or did it cover the entire apartment?
Based on my observations, most of the fire damage, the smoke, water, which I put in with the fire damage, was primarily on the second floor.
Okay. And were portions of the second floor, based on your review of the crime scene photos, more damaged than other portions?
Oh, sure. Wherever fire starts, that's going to be always the area where you find the most damage. And then a fire will travel up and damage things along its way in search of oxygen to keep burning.
And based on your examination, did the fire actually, was there actually an active fire that you were able to see in the bedroom where the victims were found?
No, I did not see evidence of that.
Okay. Now, Professor Miller, you're aware that in 1993, DNA was found in Nishonda, Washington, which excluded Darryl Howard.
That's correct.
And you're aware of the condition of the victims' bodies when they were found and examined at autopsy.
I'm sorry, I missed the first
I
part.
said you were aware of the condition of the victims' bodies when they were examined at autopsy.
Oh, sure. And also their condition at the scene.
And then in 2010, semen was discovered through DNA testing in the body of Doris Washington, sperm.
That is correct.
And there was DNA typing from that. Can you please describe the difference in the sensitivities and the technology that between 1993 and 2010?
Sure, I'll be happy to. In the early 90s, specifically 1993, was actually a time when I was still working in doing crime scene work and lab work. And that was a time where we were beginning to see the use of DNA, specifically RFLP. And I can very distinctly remember reading a research article that suggested the quantity of DNA that would be necessary to do an allelic profile, a DNA profile at that time would be the size of a quarter. And that was the state of the art. It took quite some time to get the reaction to occur as well. Shortly thereafter, they came up with a little bit more of a sensitive technique using some PCR techniques. But conversely now, in 2010, we're doing much more sensitive techniques. They allow us to find nanogram quantities of DNA that are present, which is very, very different than the quarter size.
Based upon your review of the autopsy reports, the DNA analysis was done in 1993, and then the subsequent DNA analysis that was done in 2010. Do you have an opinion as to whether a sexual assault took place in connection with these murders at this crime scene?
I do.
And what is that opinion?
That there was a sexual assault committed at this crime scene.
And can you provide the basis for that opinion?
Well, even if we look at the difference in sensitivities in 1991 versus 2010, they were able to identify semen in the presence of spermatozoa heads, and they were able to get an allelic profile from the sperm section. That the victim's a female. She's not going to have sperm. And then later on, when the more sensitive techniques that pick up all of the contributors, the samples, they were able to identify the spermatozoa in Doris Washington as well. Once again, she's a woman. She's not going to have semen in her unless it was deposited there by a man.
And as Ms. Ellis pointed out with the last witness, there was evidence of a sexual assault with an object on Doris Washington.
There was. The autopsy made that very clear, that there was a laceration. I think it was right around 4 inches inside the vagina.
And the presence of sperm would also indicate that there may have been a sexual assault with the penis as well. That would certainly be consistent with that.
Well, sharp objects usually don't leave semen.
And you're familiar with the manner of death for both Doris Washington and Nishonda Washington?
I am.
Can you describe just very briefly what your understanding is for the way that Nishonda Washington was killed?
Yes, the daughter died from strangulation. You could see in the autopsy photographs and the ligature marks on her neck and the autopsy conclusion based on strangulation. The other victim, Doris Washington, died as a result of, I believe it was termed blunt force trauma to the abdomen area, that basically she bled out or exsanguinated inside. There were marks, ligature marks as well on her neck, and it was my understanding that there might have been a secondary factor, but she died because of the exsanguination.
In light of the fact that both women were found nude, that there was evidence of sperm in both of them from different men, given the way they died between ligature, strangulation, and beating, and a laceration in Doris Washington's vaginal canal, do you have an opinion as to whether the killers would have left DNA in and on these women?
I do.
And what is that opinion?
Absolutely. As a crime scene investigator and a forensic scientist, that would be clear evidence to look for.
And it's your understanding that no DNA from Mr. Howard has been found on any item tested from any of these women?
That's my understanding, yes.
And do you have an opinion as to what the significance of the fact that we now have DNA showing sperm in Doris Washington that excludes Darryl Howard, and a different man with sperm in Nishonda Washington that excludes Darryl Howard, and no testing, fingernails, or anything else showed Darryl Howard?
I am aware of that, and my conclusion is Darryl Howard was not present at this crime scene to perpetrate those crimes.
I have no further questions.
Cross-exam.
Thank you. Can you talk to me a little about scene security and what your knowledge is of that?
Well, crime scene security is not established to keep the public out. What crime scene security is intended to do is to maintain the integrity of the physical evidence that's in the crime scene. And it has been my personal experience that the best way to accomplish that is by doing a layered approach to doing it. The reality is that oftentimes doesn't happen.
And can you tell me about, you stated that it's maintained to establish the integrity of that crime scene?
To maintain it,
Maintain it.
not just establish it, but maintain it.
Maintain it. Can you tell me what factors go into maintaining the security of or the integrity of a crime scene?
Well, the biggest technique is simply to reduce the number of people that are in and out of a crime scene. And that in and of itself is the greatest way to maintain the integrity of it. Now, once you've got crime scene investigators in the crime scene as well, you don't want them to alter or change the evidence as well. And for that reason, crime scene investigator, dons the gloves at least. In the early 90s, we would simply use that as sufficient. Occasionally, you would put booties on to prevent you changing or altering by walking around. Nowadays, with the significance of the trace evidence that can be found and preserved and subsequently tested at a crime scene, we use Tyvek suits. We'll restrain hair, cover hair, we put masks on the faces as well.
Okay. And that's actually kind of the basis of the Lockhart theory, correct?
Well, the low card exchange principle, oftentimes I have a difficult time explaining to police officers when we're on a crime scene because they're interested in doing what they can. And in their exuberance, sometimes they forget that the low card exchange principle simply states that whenever there are two objects or surfaces that contact, there will be exchange of matter between them. That forms the basis of why we go to crime scenes. Because we go to a crime scene to find the evidence that has been brought in by a suspect. In some cases, we use the evidence at crime scenes to corroborate that a victim has been in the crime scene as well, because sometimes they're not always there. And so for that reason, we want to try and maintain the security of the crime scene to minimize any of that cross-contamination that could happen as a result of the low card exchange principle.
And that works both ways, though. What comes in can sometimes be tracked in by other people, and what goes out, or what was there, can actually be tracked out by
Sure, it goes both ways.
Okay. Now tell me about transient evidence.
Well, transient evidence is temporary evidence or evidence that's easily lost. An example might be, for instance, a bloody footwear impression at a point of entry at a crime scene. If that's the only point of entry, all of the people going in and out of the crime scene might cause that evidence to be lost. Most trained crime scene investigators know that if you've got to recognize this transient evidence and to preserve it once you get into the scene, therefore you minimize the loss of it.
What other types of evidence are transient?
Well, smoke, since we're talking about arsons, the color of smoke at a fire can oftentimes give you an indication of the nature of the accelerant. Transient evidence could be an odor, could be a melting dish of ice cream at a crime scene as well.
What about fingerprints?
Fingerprints actually are a pretty hardy type of evidence. It takes a concerted effort to lose fingerprints, especially now given the techniques that we've had for years and our newer techniques that allow us to find them. That's not to say that if I walked into a crime scene that on a doorknob it had a fingerprint, I'd use the doorknob. Would I obliterate them? Probably, but that's what we call one of those focal points that in a crime scene they've got a high probability of finding the evidence, so you process it, you look for the fingerprints.
But you've talked about, and this is one of the things that I'm really interested in, is it's changed a lot. I mean, how we process crime scenes and how we look at crime scenes has changed significantly since the 90s. And this case was actually 1991, correct?
Parts of it have. I think that if I had to give you my observation of somebody that's been actively involved in crime scene investigation and also the education of potential crime scene investigators, the areas where it has changed is in our searching techniques for the evidence. We have much better ways of enhancing and visualizing and searching and locating the evidence. It's not a haphazard process, but it's also, it never has supposed to have been a haphazard process. It's one now that We can use light sources. We can use chemical enhancement. We can even take some laboratory instruments to the crime scene. So nowadays, it's better than it was in that we can find it more readily.
Now, talk to me about conditional evidence.
Well, conditional evidence is evidence that is created as a result of an action. A light switch that would ordinarily be turned off has been turned on. A telephone receiver that is off the hook is off the hook because someone took it off the hook. In this case, I would say that conditional evidence would be the semen found in the vaginas of the victims. That had to be deposited there by the result of an action. In this case, a sexual assault.
And you talk about the true objective of a piece of evidence and that value being able to, it's the benchmark of the reliability of a witness.
Well, it's one of the things that physical evidence has value for. In other words, it can support what an eyewitness says, and it can also show that an eyewitness has either forgotten something or is lying about something or just doesn't know and is making stuff up.
Or it can show that they are testifying precisely in line with physical evidence.
Yeah, if indeed the physical evidence supports what they're saying, yeah, absolutely. That's a perfect scenario.
So in this picture that defense brought up to you, defense 17 and 18, where it's showing the item that was moved, you can't say for sure whether that is, you've got a copy, that you can't say for sure whether that is the Nintendo unit there.
I cannot say it is a Nintendo unit. I can tell you it's an electronic unit of some sort because I can see the little RCA slots in it.
Okay, but you can't tell me that that is the unit that was up on the television.
No, but if I were able to maybe look at other physical evidence, so for instance, measure the size of the dust on the top of the television, then I might be able to support that it was there.
However, if, as we talked about his kind of going through and saying if we take this trial transcript, and we look through it and we saw that Tanika Jackson, all of these individuals testified that there was a VCR stolen and that they saw him with a VCR coming out of the house, that would be evidence.
Well, I would certainly support those eyewitnesses' accounts by looking for maybe connectors for a VCR. I would maybe, once again, measure the dust here. I would, if there's dust on top of this, that may indicate that there was something sitting on top of it as well. I would take that testimony and try and find the physical evidence that supports it.
And that's...
And what I am seeing in this is that there is an electronic unit there. I'm guessing it's a Game Boy, but I certainly see a spot on the television that would be consistent to my eye as possibly being a VCR or a Game Boy. I don't see that in the other photograph, so I'd be a little hesitant, and especially since it's got rabbit ears, I would suspect that's probably not something that a VCR is hooked up to. But I would then look behind the cabinet, look for connectors. I would verify what people say.
Right, and but this is what the jury heard, is that they heard all of these individuals say that he came out with a VCR, that he came out with a VCR, and then they saw pictures.
They didn't all say that. They all said television, and one added a VCR on top of it.
Your Honor, I stand corrected on that.
Well, but you know what I would do is I would look for the VCR.
Right, and what if I told you that the trial transcript also stated that Mr. Howard admits to having the VCR on that night?
Then once again, I would, because that's what is being said, not necessarily what I see in front of me, I would want to verify that by finding the VCR.
Correct, but so in this, you can't really tell us what happened based on that. You can't really tell us any conclusory evidence based on that what the witnesses saw was not what happened.
Well, what I see and the physical evidence that I see, not necessarily what they're saying, but what I see in these photos are televisions that are still present, and I see electronics that are still present. And that's when if I could ask for further physical evidence to vouch for what they're saying, then I would ask for that.
Now, a really good person to talk to about your findings here would be the actual person who processed the scene.
What do you mean process?
Who came through and looked at the evidence in the scene.
Just visually looked at it, or see
No,
when you say process to a crime scene investigator, you're talking about searching for other physical evidence, looking
Correct.
for physiological fluids, looking for fingerprints, looking for hairs and fibers. So it was my best recollection reading the materials that were given to me that there was no attempt to do any fingerprint processing.
Okay, and but the rest of it, looking through and just the process of taking the photos and diagramming, that's still processing the crime scene, correct?
But here again, that crime scene sketch wasn't done by a crime scene investigator. It was done by a fire investigator. And the photographs, frankly, they're not very good. So,
Right.
so I would have questions about how good the, quote, crime scene investigation was based on the materials that I've seen.
And did you reach out to the crime scene investigator to talk to him about it?
No, I did not.
And why was that?
In all of the cases that I've ever done, I've never actually talked to the investigators. Instead, I'm relying on their work product or their actual testimony, which is kind of what I've always been limited to looking at.
It's always, why?
Because it's adversarial. And in many times I would love to call them up and talk to them, and they will say, oh, well, you're working for, so-and-so, and I can't talk to you. Now, if I, were meeting them at the local pub or at the sports bar or something, I could probably talk to them. But in this system that we have, they're really not all that inviting to talk to me about it. Instead, and that's why I rely on what they write, their official documentation of the crime scene. That's what I have to work with.
Well, and I'm just a little bit, I'm going to go back to a different question. Because I do have Mr. Campen here. I mean, he's old now, but.
Aren't we all?
He's here.
Object to that last remark.
Maybe I shouldn't answer because you've termed us old, okay?
Sustained.
Thank you. And I'm a little bit confused because you stated his question, was there sexual assault? And you said yes, because they're women and they don't have semen in their vagina, so automatically that is a sexual assault. Are you saying consensual sex is an automatic assault?
No, what I'm saying is, given that we have two women who have been subjected to some physical abuse, they are found in this crime scene that is attempted to be disguised by burning it down, that absolutely there's been criminal behavior at this scene. They are nude on the bed. They are not in a normal sleeping condition, and that goes with everything that I've ever done in my entire career, that those are sites of potential physical evidence, sexual assault. Let's check it out.
Let's check it out, but aren't there situations where there are murders but no sexual assault, but yet boyfriend's DNA is in there?
Sure, but that's not the circumstance we have in this case. We've got two women who have been physically abused, so much so that one of them is basically bleeding out and dying on the bed. They're nude, they've got ligature marks. It's just routine procedure, and that's how this was investigated even back in '91, was let's get what we used to call the sexual assault specimens.
Yeah, you're saying that one of them, you were able to go through the testimony of the medical examiner.
Yes.
And there was no sign of trauma to the vaginal area or the anus area of Nishonda Washington.
The younger one. No, there was not. The trauma was to her neck area. There was bruising. And then Doris had the same ligature marks, but she also had some other abrasions, as I recall, on her back as well. this is all indicative at that stage of the investigation that you find the physical evidence that helps you figure out what happened. And in this case, the semen samples were found in the daughter, and then even now, you know, many years later, they were found in the mother.
Yet there was nothing under their nails or anything like that. And you said that they were viciously attacked and beaten.
I wasn't there to collect those specimens, and I believe reading they were collected, but I don't believe anything was ever done with them.
Would you be shocked to find out that they were sent to the lab and that Ms. Clement just testified about it?
Well, and right now I don't remember reading about the results of the fingernail scrapings, but certainly they should have been collected and looked at. And the results interpreted from that as well.
Okay. Can you tell me about the disruption of a crime scene and why that's important?
A disruption of a crime scene. In other words, as it's being investigated or as the crime scene is occurring, how are you using disruption?
I'm just taking this straight from your book.
Which one?
I believe this is your book with Mr. Lee.
Yeah, that's the older book. Mm-hmm. In the context of that particular textbook, disruption of a crime scene has to do both in as the scene is occurring, there can be a disruption, people get interrupted in what they're doing, but the biggest disruption that can happen at crime scenes is that they're not secure, that there are changes or alterations in it. And frankly, sometimes firemen have a tendency to disrupt crime scenes in their efforts to put out the fire.
What kind of disruption?
It's called coming in with a, it's called coming in and breaking all the windows, maybe opening doors, dumping water on fires. So what one, as a crime scene investigator that's looking at a homicide that, or any kind of a crime that has occurred in correlation with a fire, you have to take that as a baseline and do what you can given sometimes the disruption that occurs.
Okay, and now page 51 of that book also stated that you shouldn't smoke at a crime scene. Is there a reason for that?
It's introducing physiological fluids, it's entering foreign substances. It's, you know, part of the reason why we do the low-card exchange principle. If someone's smoking on the scene and, you know, they throw a cigarette butt or they drop ashes on it, they could disrupt the evidence at the scene. We tell crime scene investigators not to drink on a crime scene for those very reasons as well.
Now, what types, you can actually wash touch DNA off?
You can wash off contact DNA, but the part that's interesting about it is if we're talking about washing your hands to get rid of the DNA, you have a constant source of DNA. You can wash off those cells, but guess what? You've got more that are going to take their place. So that's why we put gloves on, so we don't slough off those cells that would contaminate.
Now, you also talk about what types of pieces of evidence would you believe that you could have found at this scene?
Well, judging by what I saw on the first floor, and the fact that this homicide assault occurred in this apartment, and we can't say it only happened in one place or another, I would find it very difficult to search for evidence in the bedroom where the fire started. That's where you're going to have your heaviest disruption of evidence that might be displaced there, because you've got the fire that's burning up, it's going to hit the ceiling and it starts to spread. That point of origin is going to be the area where the fire department goes in, and that's what they focus on. They're going to put that out first. Okay, so that's an area that has super high disruption. Okay, the rest of the second floor absolutely is going to have some smoke disruption. However, the best evidence in this case isn't going to be disrupted by the firefighting efforts because it's inside the two victims. It's protected. The first floor, doesn't appear to be damaged at all. And that would have been an area that certainly, given the fact that it happened in this apartment, I would be doing everything I could to find any and all evidence on the first floor.
I want to go back to something that you said, that this had obviously been kind of staged.
No, I don't think I said staged.
You said that it was altered so that it could be, that evidence could be destroyed with the starting of the fire.
That's not staging. That's just what somebody with intent tried to do at this crime scene, to set a fire and burn it down. It happens.
Okay. And why would they do that?
To destroy any evidence that might be left and present, to disrupt it.
And they would take whatever accelerants they had there.
If they had accelerants, you know, things burn, paper burns.
Okay.
I'd be looking for an ignition source in that situation. So when looking at an arson scene, you look for the V pattern where a fire starts. And then what you do is you look in that area for any added accelerants or something that could have been used to combust, but also it takes ignition. You're gonna have to have some sort, you know, book of matches, a lighter, something that started the fire as well. So when I see a fire scene, irrespective of all the other evidence that I would be looking for, I'd go to that point of origin and see if there are things in that environment.
So once again, I'm a little confused, because you're saying that basically the only evidence that you see of anything in here is inside, protected, inside the victim.
Based on the work that was done at this crime scene, the only physical evidence that was not disrupted by the fire on the second floor anyway, that was found by the investigator at the scene, is the material that was found within the bodies, or the bodies themselves of the victim.
So,
but you know, and also to continue answering my question, I would like to say that there were some areas that were not looked at. I mean, there was nothing done to the first floor, and there were tons of things that could have been done on the first floor that were not done incorrectly, with an incorrect conclusion reached that there was too much smoke damage, too much water damage on the first floor. And that is not my observation at all, that there were many things that could have been done on the first floor. There were many things in the bedroom where the bodies were found that could have been processed. I mean, Defendant's Exhibit 17, you can see there's a chest of drawers near the bed. The sheet that was on the bed could absolutely have been collected and searched, you know, for drainage out of these two women's bodies. Hairs from the suspects, hair from the victims. There could have been so much more that was done. But based on what was done at this scene, the only evidence that has probative value for me as someone who looks for evidence at a crime scene is the evidence that was preserved inside the bodies of these victims.
now did you read the notes that the officers and the firefighters did about the crime scene themselves, that there was actually a broken axe pick, they used shovels, that they used an air pulling device to get the smoke out?
I don't remember the axe and the pick and the shovels, but that's common stuff used by firefighters, and that's part of their firefighting process.
Correct. Now, can you tell me, have you...
And those would have done, I might add, near the point of origin,
Okay.
not near the other bedroom where the victims were found.
And were you able to pinpoint where those were?
Where what?
Where those fans were used?
No, and they usually are done in doorways or windows.
Usually, but did you know exactly where they were placed in
No,
this?
I do not know.
Can you tell me, are you familiar with those devices?
Well, having suffered a fire in my lab, yes, I know what they do.
And would you say they disrupt the airflow? They can move items that are transient and can get rid of a lot of information?
They could, potentially, yes.
And so I respect your credentials. Obviously, I've called you as a witness myself. But I just want to talk to you about how long has it been since you've actually been on a scene?
I was called by the Attorney General's office in New Hampshire to respond to a homicide, best guess 6, 7 years ago, as a primary responder. That scene was held for me. That was probably the most recent one. But admittedly, most of my work is either at scenes that I create in my own laboratory, scenarios I create in my own laboratory, or based on work products from scenes.
Yeah. And how long has it been since you've been on an arson scene?
If you don't count my own lab burning accidentally. It was probably in Asheville, and it was to hide a homicide sexual assault, and that would be 22, 23 years ago.
And can you tell me a little bit about that one?
It was a woman who allowed a man to come into her apartment, and he assaulted her, and I think he stabbed her. I hate to say that I'm old and I don't necessarily remember the specifics of it, but it has been some time. And that was a case where he took a pile of newspapers in a closet and tried to burn down the apartment.
Now, would you be surprised to note that the witnesses in this case said that they saw them carrying some sort of electronic items wrapped in some other blankets or materials?
Would it surprise me?
No.
Gotcha.
I don't specifically remember reading that, but we'll presume that I'm not surprised to hear that.
Okay. So basically, in this case,
And you know, if I may, since
Absolutely.
we're looking at physical evidence, if I have a witness that says they saw that, once again, find the VCR, find me whatever is wrapped in, and then you can support what they're saying.
can you always do that?
Well, that's the premise as me as a science-based crime scene investigator does is, you know, I can shoot you here in the courtroom and I witness it, I've done it, but I'm, as a scientist, what I'm going to do is I'm going to look for the evidence. I'm going to look for the gun, I'm going to look for the GSR, I'm going to look for the casing, the projectile, the backspatter from it. I'm going to support because it's
And who has control of
it's
that?
probably pretty clear right now that I don't have the best memory because I am getting older, even though we're not going to use that term. Indeed, I would look for the physical evidence that would support what maybe other witnesses in here saw happen in that scenario. And that's the premise of forensic science and the testing of evidence and the investigation of crime scenes, is that we have that evidence. That's the objective evidence. That's not the subjective eyewitness.
Correct, but who controls that evidence? Who
The-
controls where the gun goes?
Well, the crime scene investigator obviously is going to be the person that does everything they can to find it. I mean, that's probably the basis for our OSAC right there, is that
Right,
we
but-
are trying to write standards for these people going to crime scenes to make sure that they are doing what they can to find the evidence.
But ultimately, the defendant has that control over the disposition of those items that are used in his criminality, correct?
I'm not sure I know what kind of hypothetical you're suggesting
I'm not saying
here.
a hypothetical. I'm saying in any crime, the defendant who commits that crime has the ultimate power and control over the disposition of his instruments of criminality, correct?
Well, the good part of that is no, they don't, because most of them are not aware that they're leaving physical evidence behind. That's the presumption, is that they're not always consciously aware of the evidence they're leaving behind. Now, if they're going to wrap themselves in saran wrap or wear double gloves, you know, double condoms, whatever you want, cover their shoes, their feet, then they are making that conscious effort. They understand the concept of Lockhart, of leaving the evidence. But quite frankly, most of them do not. They are not aware that they're leaving this stuff behind. And, thank you, CSI on television, for making it aware for everybody. But it also shows that I really believe that most of them are not really aware of what they're leaving behind. They wear gloves to get fingerprints covered, but they forget about their shoes. And the pattern of their shoes are just as individualizable as their fingerprints.
But this case didn't have shoes or anything like that. It has a VCR that was taken away from the scene, and who had control of that?
Well,
The defendant, correct?
This scene has lots of eyewitness testimony,
Correct.
but it also has really good physical evidence in the DNA evidence that was found.
But you are not a geneticist, correct?
I am not a geneticist.
You've got a really good background in chemistry, but you have, how long can DNA stay intact in the vaginal area?
Well, in my old days of being a serologist and testing that sort of evidence, it's highly dependent upon the movements of the victims or the vaults that hold the evidence. In this particular case, we don't have movement. We've got 2 women that are dead on the bed. That's going to give very good evidence. And it's protected from a fire. It's protected from disruption because it's inside.
But you're not answering my question. Can you tell me how long ago that sperm was deposited in them?
No, I can't tell you that.
So
In the good old, as I said,
hours.
it could have been hours, it could have been minutes, it could have
been days.
Yeah, if it were days, then based on what we have in the way of knowing that these 2 women were alive before they were killed, my guess is if that assault had occurred and they were up moving around, it would have been lost. We wouldn't have seen it, but it's still there. And so indicating either they're not moving or it was recently deposited. And you are getting a little beyond my scope.
Correct.
But as a crime scene investigator, given the scenario we have at this crime scene, it is absolutely evidence that you look for. And you take not just the bodies and the hospital specimens or the sexual assault specimens, but you take every other item of evidence around that area in the crime scene to support or refute what witnesses are saying, but also to provide investigative leads as to who did this.
Well, if Mr. Howard told police officers and everybody knew that he had been in that house numerous times, wouldn't the absence of evidence also be as incriminating?
In this situation, I would say absolutely that we should have been able to find presence of him. If he said that he was in this house, then we should be looking for that evidence in that house.
So the absence of evidence also shows that somebody could have actually taken steps to secure that crime scene because he knew that that he didn't deposit that sperm in there, and he knew and he perpetuated this story. That if you can't match me to the sex, you can't match me to the homicides.
But nobody looked. Nobody looked for any evidence that would have been there other than what we have in the way of concrete evidence in the vaginas of these 2 women. And absolutely, if I am at this scene, I believe that there will be evidence of people at crime scenes, of suspects, of victims at scenes. That's the Lockhart exchange principle. So I disagree with the premise of the absence of evidence is not the evidence of absence, because that refutes the whole point of why crime scene investigators go to crime scene. You could have been at that crime scene if we're looking at the absence of evidence, because we didn't find you there either. You could have been there. But that's why I refute that principle or that theory, because I really believe that if a crime scene investigator is using the physical evidence properly, or at least finding it, then you're not going to have the absence of evidence.
But you've also looked through, you stated that you looked through the testimony, you looked through all the court records and everything looking through this case, correct?
I did not look at everything, but I looked at the stuff we talked about.
Okay, so you looked through crime scene, the notes, the testimony of Eric Campa. Did you look through the rest of the testimony?
I looked at the testimony of,
Eric Campa?
I looked at his testimony, I looked at the testimony of
McLaughlin?
McLaughlin and Vandergriff.
Okay. Did you happen to look at the defendant's testimony?
No, I did not.
Not at all?
No.
Did you look at any of the witnesses' testimony to see if your pattern, if the benchmark of reliability wouldn't be the witnesses? Why wouldn't you look at the testimony of the witnesses?
I don't remember reading any testimony of the witnesses. I did, however, read statements that people gave to the police department in this issue. And as I'm reviewing their statements, what I'm doing is what they're saying. I pick out the items of evidence that would support or refute what they're saying. I call it a verification process as I'm looking through that. In some cases I can and some I can't. I'm somewhat limited by the materials that were, the photographs, the sketches, the notes of what were done. That's all I can do is rely on what the people, the crime scene investigators and the other investigators, what they use as their work product from those crime scenes. That's all I can use.
And so you weren't able to look at the testimony and see how they responded to cross-examination on their information that they gave?
The closest thing I got to looking at how their testimony was given was in Mr. Nifong's closing.
Mm-hmm.
But other than that, I looked at their statements that they actually gave close to the time of the occurrence.
And their statements close to the time, in conjunction with their testimony, would have been what a jury saw and a jury would have been able to evaluate. And there are credibility issues there that a crime scene analyst cannot evaluate. Isn't that true?
Well, what someone says in testimony and in their statements absolutely can be verified with what the actual physical evidence is at the crime scene.
That's not my question.
Well, I'm sorry, I thought I was answering it. What they write in their statements, what they give testimony about from my viewpoint as a crime scene investigator must be verified by what is actually found at the scene.
Correct. And what I'm asking is that their testimony and their demeanor, and in conjunction with the statements that they made at the time to a jury, is something that a crime scene analyst can't analyze.
Yeah, I can't reach any conclusion about what that jury is doing. I look at the evidence to verify what they're saying.
Right. And in that, looking at that, you can't say there was no other evidence in that house that Jermac Jones was there, except for his semen.
That's physical evidence.
That is
shows
physical
that
evidence.
was there.
Okay. Could sex have occurred that was not there and that semen come into the house?
Here again, I can't say when it was deposited, but it was there.
But it is possible that that semen did not originate in that vagina in that house at that specific time. Is that correct?
Based on the only physical evidence we have now, yes. That's why I would look for something like the sheets to be collected or any other evidence that would help put together a proper timeline development for this evidence. And that was not done.
So based on that information here, you cannot say that this DNA conclusively exonerates Mr. Howard, can you?
That's not the standard, Your Honor.
Sustain.
You don't know when that DNA was put there. You don't know where that DNA was put there, is that correct?
I know it's not Darryl Howard's DNA. And otherwise, I don't know when it was put there.
And the jury knew that it was not Darryl Howard's DNA too, correct?
For the daughter, yes.
The jury knew that the DNA did not match Darryl Howard, correct?
Are we talking about the DNA? This would be from the daughter.
Correct.
That is correct.
The DNA from the daughter and the DNA from the mother didn't match Darryl Howard.
It was my understanding that the DNA in the mother was not known at the trial, so you're confusing me. So,
Well, I'm just
so ask a couple questions there.
No, I'm just saying now that DNA still doesn't connect Darryl Howard.
None of the DNA found in either Doris or the daughter came from Darryl Howard.
And you read the trial transcript and you knew that the argument before the jury was that the DNA did not match because there was no sexual assault by the person who committed the crime. That was their argument?
That was argument of, and what I'm saying is what I know based on the evidence is that DNA was not Darryl Howard's.
Right, and what I'm asking is that you got to read the trial transcript, correct?
Not the whole trial, no.
Okay, not the whole trial, but you read the closing arguments?
I read the closing arguments, yes.
And was it the defense posture in that trial that whoever raped Nishonda and Doris,
And
if it
assaulted
was a
Doris.
rape or an assault, killed them? That was their theory, correct?
And that's what I would believe too if I were the crime scene investigator looking at the evidence and what we see at the scene. It would be my experienced eye as a crime scene investigator that these are happening at the same time because of where they are found at the crime scene and the nature of the attempted disruption of the crime scene.
But they put that before the jury, and the jury heard all of the witnesses and saw all of the evidence and heard all of the testimony, including the fact that the DNA did not come back to Darryl Howard, and they found him guilty, correct?
That's my understanding, yes.
Thank you. No further questions, Your Honor.
Just a few follow-ups, Your Honor. You talked about the most reliable evidence in this case is the evidence that it was within these two women.
That was the evidence that was subjected to, and I'm going to use the disruption aspect of this. It wasn't changed or altered. It was basically in a nice, safe, secure location.
Is there any evidence that you're aware of that the firefighters brought in Jermac Jones's DNA?
I didn't see that in any of the materials I looked at.
And certainly the firefighters didn't disrupt the scene so much they actually inserted evidence into these women, did they?
No, of course not.
And just so we all understand what's going on here, at the time of the trial, what we had was one DNA result on Nishonda and no DNA results from Doris.
Correct.
And what we know now is we have DNA results from Doris and they show two different men.
There were two different DNA profiles at this crime scene.
And the DNA profiles are actually different from these victims.
Yes, they were.
And when Jermac Jones, who was found inside Doris Washington, was confronted, he claimed he'd never touched her.
Objection, Your Honor. I don't think she has any knowledge of that.
No, I'll rephrase.
No, I don't.
If the court should find from the evidence and by its greater weight that when Jermac Jones was confronted about his DNA being inside Doris Washington, this homicide victim, he indicated he had never touched her and didn't know her. I'd like you to assume that.
Okay.
As a forensic scientist, is that true?
No. He's mistaken or lying.
And if the court were further to find from the evidence and by its greater weight that he claimed he had never even been inside this home, do you believe that is consistent with the truth?
No.
And finally, if he claimed he had sex with Nishonda Washington, but there's no trace of DNA on him, and he had claimed he had done that
within a relatively short period of time. Is that consistent with the truth?
No, his DNA would have been found in her if it were a relatively short period of time.
I have no further questions.
Just a few on redirect, Your Honor. The simple fact that Jermac Jones may have slept with Doris's mom does not mean that he killed her.
Well, I think he did more than sleep with her. I think he had sex with her.
Okay,
He ejaculated inside of her.
correct. And would you want to tell somebody that you're sleeping with their daughter's mom?
It's not my thing.
Correct. Okay. Your Honor, just going back to that, it still does not prove or disprove any of the evidence that was presented before the jury.
Is there a question there?
Yeah, I've lost track of the question there.
Okay. That there is semen in the vaginas of both of the victims still does not negate all of the evidence against Mr. Howard at trial.
Well, I hate to answer the question the way you've asked me because, we'd have to go through each item of evidence that you're talking about. What we have that I will agree in the way of physical evidence is we have DNA that is not Mr. Howard's at the first trial in the daughter. That's the evidence that we have. We have no, there were some fingernail scrapings, some hairs that were looked at, and that's all. The best probative evidence at this crime scene and at time of trial were the DNA samples found in the victim's body.
So, but it's still possible that they could have gone next door and had sex 24 hours earlier with somebody.
I think 24 hours is too long. I think that's getting close to that time when you're going to not find the semen left behind. I think that it is a shorter period of time. And I'm going to take the other evidence that we have at the scene is their condition and the fact that the scene is tried to be disrupted or destroyed with the fire to say that all of that happened pretty doggone close together.
But you can't state that with any type of certainty when that semen was deposited. It could have been 5 hours earlier.
It could.
It could have been 7 hours earlier.
It could.
And it might not have happened in that house.
Well, then what I would do with that scenario is I would tell the investigators, well, find me the physical evidence that would suggest it was somewhere else.
And they put that evidence before the jury, and they found him guilty.
They found statements that was putting it there, and I'm once again suggesting find the physical evidence that corroborates the statements.
In 1991, would you have been able to find all of the evidence given the disruption that happened in here?
I would have certainly looked better than what was done at this scene, because there were techniques in 1991 that certainly would have allowed them to find better evidence and additional evidence at this crime scene to find out who was there at this crime scene.
But that can be true of any crime scene. Isn't that true?
It is my hopes that it's not the case, that if we have trained, competent, science, understanding, physical evidence, understanding crime scene investigators who do their job, we don't have these issues. In Marilyn Miller's world of crime scene investigation, which is along with what the OSACs are doing and the subcommittees are doing, we don't have these problems. We don't have poor crime scene photography. We don't have poor evidence collection. We don't have someone who says, oh, there's smoke damage down here, is not going to process it for fingerprints. In my world, that does not happen. And I think that's the world of the OSACs and the NIST, is that we are getting to the point where people have standards of procedures and competent behaviors at the crime scene that does not happen.
And in 2016, we're still not in Maryland's world, are we?
We're getting there, is my hope.
We're getting there.
That's
and
my
so
hope.
Are you imposing 2016 standards on this 2000 or 1991 investigation?
I am not. I am imposing the standards that I used as a crime scene investigator in the early 90s, and I would have done more than what was done here.
But still, with that, you can't say what happened in that house based on,
I can say there was a sexual assault. The victims were placed on this bed. There was a fire started to attempt to obliterate it based only on the physical evidence I have. But I could have done so more.
Who did it?
Well, we know who didn't do it because he's not there. His DNA isn't there, and that's Darryl Howard. His DNA isn't there.
How can you say that he didn't?
His DNA isn't there.
So you're saying that every homicide must have DNA present for the killer to be identified?
No, I am not. I am saying based on the circumstances and the evidence that we have in this case, he was not there when this was done.
Hmm? So you didn't read the defendant's testimony at all?
I did not.
So you don't know that he stated that he actually got in an argument with his girlfriend because she asked Tanisha down there, because Doris had a habit of using other women to get her drugs. He liked to use women to manipulate them to get her own drugs and to have sex with guys so that both of them could get high.
I didn't read it. I don't know that.
If you're talking about a person who prostitutes for drugs, wouldn't you be shocked not to find somebody else's DNA in there?
I would certainly look for their DNA in there, and I would look for mixtures of DNA in there. I'd find what DNA I could find in there. If that's what witnesses are saying, then I would say, bring me the evidence to show me that.
So there is evidence that there was more than one individual in there.
Well, we now know that there were two individuals. One male DNA in Doris and a different one in the daughter.
That we once again cannot place a time period on when that was deposited, and that's really the crux of the matter.
Yes, and what I'm simply saying is that based on their location at the crime scene, their appearance at the crime scene, the nature of the injuries at the crime scene, that it is my belief based on this evidence and interpretation of the evidence that that happened very close and was part of the homicide.
Yet nobody ever said in any of these documents that you reviewed or any of the documents here that anybody saw a teenager skulking around.
I don't remember reading that.
Thank you. No further questions, Your Honor.
I have no questions.
All right.
Your Honor, may I leave?
It's late, but maybe there's one matter we can take care of.
All right. What's up?
We called Jermac Jones.
And I represent Mr. Jones. My name is Lisa Williams. For the sake of the court reporter, it's a fairly recent appointment that came in today, Judge. I anticipate the matters to be brief, but I've had limited time to counsel with him on the absolute appropriate response to any questions. Given the hour, if it's possible to do him first thing in the morning, that would be my preference. I do expect an invocation. I want to make sure that he's positive on the wording of it as well.
I'm sorry, I thought you said that you were positive.
Forget
it. We'll do it.
No. Positive of the wording that he needs to use to preserve the record is what I'm trying to say. I don't anticipate him answering any questions. I want to be clear about that. But there's specific phraseology. He's not met me long. I think it'd be a benefit if I could even have 5 minutes with him. So I would either ask for that or do it first thing in the morning. But I do expect an invocation of his rights, to be clear.
They'll be sick.
Whichever.
We'll do it in the morning.
Okay. I think it'll be very brief. Thank you. I'll meet with him now. I think it'll be very brief, his testimony, but I would request some time to make sure that he understands the appropriate phraseology.
Your Honor, and given the hour, I would just ask that we go ahead and break for the evening and take care of that tomorrow morning.
Yeah,
That will
we'll-
give him or her substantial time with her client.
All right, yeah, we'll do it tomorrow. What do you anticipate the court doing?
What do I anticipate the court doing?
Yes.
Recognizing his Fifth Amendment rights and acting appropriately. That's my expectation. I'm sorry, I don't mean to be facetious in any manner, but that's my expectation.
All right, we got anything else? Anything else?
Not pending, Your Honor. I assume you don't want us to call another witness, so, but we can't.
I think my court reporter doesn't want you to call.
Yes.
I don't really care, but
She's the only one working.
I think we got staff here.
So nothing more for the defendant, Sean?
Now, we're finished today.
9:30 or 10, we should be back on.
I don't do 10 o'clock, except on Monday. 9:30.
9:30.
Court's on recess till 9:30 tomorrow morning. So,